Hello, everybody, and welcome to History Bite number 95, dated October 28th, 2020. I'm Walter, your mobile historian and blue-collar scholar. This History Bite is entitled Selective Incorporation. Many of you may not know that the Federal Bill of Rights, specifically Amendments 1 through 8 of the U.S. Constitution, did not originally apply to the states. Instead, these amendments only applied to the federal government. They only restricted federal power. They did not in any way restrict the power of the individual U.S. states. After the adoption of the Bill of Rights in 1791, it still remained, however, to many, an open question as to whether or not the Federal Bill of Rights was intended to additionally restrict state power as well as federal power. It was not in question as to whether or not the Bill of Rights limited the power of the federal government, but to many, it remained an open question as to whether or not states were also bound by the provisions of the Bill of Rights in the U.S. Constitution. The matter finally found its way into litigation in the early 1830s. And in the case of Barone versus Baltimore, 1833, it was judicially determined by the Supreme Court of the United States that the Federal Bill of Rights did not apply to the states. They were adopted to exclusively restrict the power of the federal government, or, as Chief Justice John Marshall wrote, the powers of the general government. They were not intended ever to limit the power of the state governments or the localities within the U.S. states. So with the Supreme Court's decision in Barone, that ended the debate for more than 30 years as to whether or not the Bill of Rights was designed to restrict the powers of the U.S. states. That, however, came to an end with the adoption of the 14th Amendment to the U.S. Constitution in July of 1868. The 14th Amendment was adopted for many reasons, of course, but one of those reasons, arguably, was to incorporate the Federal Bill of Rights to the states, thus overturning the Supreme Court's decision in Barone versus Baltimore. Now, the avenue within the 14th Amendment, which that would be carried out, remained in dispute, creating two specific schools of thought here. There were many. First, let me give you the avenues. The 14th Amendment contains two possible avenues for incorporation. First, the Privileges or Immunities Clause, which, by the way, limits itself to American citizens only, and the Due Process Clause, which requires due process of law be given to all within a state's borders. All right. It doesn't just limit itself to American citizens. And lots of people, still to this day, believe that the Privileges or Immunities Clause was the clause intended to incorporate the Bill of Rights to the states. Okay. This is not a group that has won over the vast majority of the legal community, obviously, because the Privileges or Immunities Clause has never been used by a majority of the Supreme Court to incorporate any of the Bill of Rights to the states. All right. Indeed, the Supreme Court effectively gutted the Privileges or Immunities Clause of any real meaningful use with the slaughterhouse cases of 1873. Okay, so the Privileges or Immunities Clause has never honestly been given a chance at a productive life. Okay, and with that in mind, even with the pure and clean language of the 14th Amendment, the Supreme Court didn't accept the proposition in the beginning that the language of the amendment was intended to incorporate the Bill of Rights against the states. Okay. In the case of U.S. versus Cruikshank in 1876, the court rejected that very argument, that the First and Second Amendments were applicable to the states via the Bill of Rights. Okay. And in Hurtado versus California in 1884, the court once again rejected the offer to incorporate any of the, specifically in that case, part of the Fifth Amendment against the states. Okay? It would not be, in fact, until 1897 with the case of Chicago, Burlington, and Quincy Railroad Company versus City of Chicago, 1897, again, that the very first part of the Federal Bill of Rights was incorporated against the state governments. Okay? And in Chicago, Burlington, and Quincy Railroad versus Chicago, okay, the court incorporated the takings clause of the Fifth Amendment regarding the taking of private property without just compensation. The court incorporated that clause against the states, requiring that the states provide just compensation when private property is taken. All right, they incorporated this through the Due Process Clause of the 14th Amendment. Since that time, all right, the Supreme Court of the United States, of course, has incorporated virtually all of the remaining parts of the Federal Bill of Rights to the state governments, restricting state power, all right, with these amendments, okay? Now, with that case that we just covered, Chicago, Burlington, and Quincy Railroad Code versus City of Chicago, 1897, that being the first case incorporated against the states, the most recent one was Timms versus Indiana, 2019, where the court incorporated the Eighth Amendment's excessive fines clause against the states. Okay? So from 1897 all the way to the present day, so we're talking about the 1920s, okay? The 1930s, 40s, 50s, 60s, 70s, okay? All the way up until the present day, virtually all of the Federal Bill of Rights have been incorporated against the states, okay? Restricting state power in all of these areas, okay? To date, none of the Seventh Amendment to the U.S. Constitution has been incorporated against the states, okay? And there are other provisions in the Sixth Amendment, specifically the right to a jury selected from residents of the state and district where a crime occurred, that has not been incorporated against the states. That is in the Sixth Amendment. And in the Fifth Amendment, it may surprise you that the right to indictment by a grand jury also has not been incorporated against the states, even though virtually all the states have this as a means of indicting people for serious crimes. Okay? But again, it is up to the court to incorporate the provisions of the Bill of Rights through the Due Process Clause. Okay? And that is how each and every single part of the Bill of Rights has been applied to the states through the Due Process Clause of the 14th Amendment to the U.S. Constitution. Now, let me go back real quick to the Privileges or Immunities Clause, okay? Two famous justices, Justice Hugo Black and Justice Clarence Thomas, have argued, Justice Black in the past and Justice Thomas in the present day, argued that the Privileges or Immunities Clause, okay, was the proper avenue to incorporate the Bill of Rights to the states, okay? Justice Black was not able to convince his colleagues of this during his 34 years on the court. And during those years on the court, a great many of the Bill of Rights were incorporated to the states via the 14th Amendment's Due Process Clause. For the record, Black was on the court from 1937 to 1971. And of course, Justice Thomas is a current member of the Supreme Court. Justice Thomas, however, is seen to have revitalized the Privileges or Immunities Clause, as he preferred, when he wrote his concurrence in the case of McDonald versus City of Chicago, which incorporated the Second Amendment to the states via the due process clause of the 14th Amendment, he, in his concurrence, suggested that he would have used the Privileges or Immunities Clause to incorporate the Second Amendment to the states, not the Due Process Clause. As you know, he's a very big critic of substantive due process, and so therefore he would have used privileges or immunities. All right. Nevertheless, okay, that clause, like I said, has never been used directly to incorporate any of the Bill of Rights to the states. All of the Bill of Rights that have been incorporated to the states have been via the 14th Amendment's Due Process Clause, okay, by the U.S. Supreme Court. Okay, so that, ladies and gentlemen, from the period of 1897 up into last year, all right, almost all of the Federal Bill of Rights have been applied to the states with those very limited exceptions in the 5th, 6th, and 7th Amendments. All right, none of the 7th Amendment has been incorporated. All right, and one specific provision in the 5th Amendment and one specific provision in the 6th Amendment has yet to be incorporated. All right. So that is the process of selective incorporation, with the Supreme Court selectively incorporating various provisions of the Federal Bill of Rights to the states via the 14th Amendment's Due Process Clause. All right. So I thank you very much for listening to this History Bite. Hope you learned a thing or two from it. Any questions or controversies, leave them down below and I'll be happy to answer. Take care, stay safe out there, and if you haven't subscribed, please do. Thanks a lot. Have a good one.